Good afternoon to our audiences in Korea and Asia. Good morning to those of you who are joining from Europe. Thank you very much for attending this year's IPR Conference, one of our long-standing yearly highlight events. This is Na, Manager of IPR and Fashion and Retail Committee at the European Chamber of Commerce in Korea. I will be moderating today's session. So in order to allow for a smooth progress of the event, please note that you are automatically muted and your video has been turned off. Also, we are providing the simultaneous interpretation for the whole session. So please feel free to click the below globe button in Zoom and choose your preferred language for the presentation. We are delighted to have a large number of speakers at today's event. To facilitate the interaction between speakers and audiences, we included a 5-minute Q&A segment for each speaker. Therefore, please feel free to use the Zoom Q&A function and upload your questions to the chat box in case you would like to hear any further explanation on presentation. We will share your questions with our speakers and try to answer them if time allows. So to begin with, I would like to welcome Mr. Dirk Lukat, ECCK Chairperson, to deliver his welcome remarks.
A warm welcome.
Ladies and gentlemen.
A warm welcome, ladies and gentlemen. The ECCK was founded almost 9 years ago, and I'm proud to say that IPR has been one of the strongest pillars of the ECCK from the very beginning. I'm further proud to say that we host the Korea EU IPR Conference already for the 9th time. The conference has developed into a key conference in Korea to facilitate information exchange and discussion on intellectual property. This conference is made possible by the strong support of the Korean Intellectual Property Office, who is our co-host, and the IP law firm NAM&NAM and Hoffmann Eitle, who are both our partners this year. In contrary to last year, this year's conference will specifically focus on anti-counterfeiting, which is the main concern not only for the trademark owners, but also for consumers, online intermediaries, and enforcement bodies. Global trade in counterfeits has never been more serious, mainly due to the exponential growth in counterfeiting activities on the internet in recent years. It is now a global phenomenon that leads the public and consumers to a false perception and hinders economic development in the long term. Both Korea and the European Commission have continuously raised awareness on anti-counterfeiting. They announced their plans to achieve a better IP environment by improving legal mechanisms for protecting of intellectual property and conducting thorough monitoring and enforcement of trademark infringement. Intellectual property dates back for many centuries, and the protection of intellectual property rights has provided a guarantee for intellectual property owners to receive adequate compensation for their creations. Especially the trademark serves as a motivation for trademark owners to protect their brand identity and value that has been accumulated for a long time. The world has become more complex and connected. It has taken a step closer to digital transformation. This is why we hope to see more harmonization in intellectual property, regulations and cooperations between the private and public sectors to achieve a common goal. Harmonization and cooperation will lead to more effective IP protection and to more transparency. Naturally, these shall be based on best practice approaches and active communication between the stakeholders. That's why I consider this conference to be so important, as it allows an opportunity for anyone, anywhere in the world to learn from today's speakers. I'm confident that today's conference will be very inspiring and allowing each and every one of you to gain valuable insights. Thank you very much.
Thank you for your remark, Dirk. Now I would like to welcome Mr. Maria Castillo-Fernandez, the EU Ambassador to the Republic of Korea.
Ladies and gentlemen, I would like to congratulate the European Chamber of Commerce in Korea for organizing this online event together with the Korean Intellectual Property Office and with the support of NAM&NAM. This is the 9th year the Chamber is organizing this conference, and it has become a reference point for all IP specialists in the Republic of Korea. I hope today's IPR conference can offer you some inciting views and innovative ideas that will guide our collective responses for going forward to overcome the COVID-19 crisis. Certainly, IPI plays an important role. IPI protection and enforcement are even more important than ever, especially to unlock the enormous potential that technologies can bring to both Europe and Korea. We are all trying to build better and build more digital, more green and more innovative. So we need to make sure that the IP infrastructure really fits for the innovative policy of the 21st century. Intellectual property certainly creates high-skilled jobs and economic growth, and this is very easily forgotten. Let me tell you that in the EU, 40% of all economic activity is generated by IPR-intensive industries. More than a third of all the jobs in Europe, around 77 million, depend either directly or indirectly on IP-intensive industries. People employed in these industries normally earn over 40% more than in other industries. In Korea, the panorama is even better. IPR-intensive industries account for 43% of Korea's GDP, employing around 6 million Koreans, an average pay of 50% more than other industries. What these figures really tell us is that IP rights, whether copyrights, patent, trademarks, trade secrets, or designs, are really the bedrock of our economies. But however, we still witness that the production and trafficking of counterfeited poses certainly a significant health and safety threat to our consumers. Studies made jointly by the European Union Intellectual Property Office and the OECD tell us that global trade in counterfeited products reached 440 billion euros in 2019. That accounts for 2.5% of total world's trade. So effective IPR enforcement is necessary, and for that close cooperation between enforcement authorities, but also between business stakeholders is key. Our business also need a solid and predictable IPR legal framework. In this sense, I believe that the Europe-Korea FTA, which has this year 10 years of age, plays a pivotal role in accessing effective ways of protecting the rights of our business. It has a very strong IPR chapter that facilitates the production and marketing of innovative and creative products. But apart from bilateral cooperation, we also need multilateral cooperation within the WTO and other appropriate forums. IPR protection will be key in the new digital world. E-commerce has emerged as a powerful source of growth for global economies. But we need, therefore, to complete the international legislative framework, which will be very important in addressing these issues. We also have to look at a wide range of other industrial level mechanisms to encourage what I think it's a comprehensive approach where we could also seek our stakeholders' cooperation. We need to reinforce this cooperation in a more international and global market. And the best way, this will be the best way certainly to overcome our hardships today. And this is what you are doing today. So thank you very much and have a productive meeting. Kansamida.
Thank you very much, Ambassador, for your warm remarks. This time, I would like to invite Mr. Benoit Misonne, IP Attaché, to the delegation of the European Union to China, assigned by the European Union Intellectual Property Office. Benoit, the floor is yours.
Thank you, and so I'm seeing messages popping up on my screen saying that the video cannot be started. So I presume that this is because you need to launch it. But I will start already, otherwise audio, and that is fine. Thank you very much, and so Madam Ambassador, Director General Moon, ladies and gentlemen, it's a pleasure to participate to today's event, a very important one, as has been mentioned. Madam Ambassador has mentioned on the study that was published in a bit recently with numbers of 2019, with the 414 billion of counterfeit products trafficking through global trade. This is something that is not only hindering economic development, but it also leads to the public and consumers to false perceptions. Voilà, and so I think it was a problem on my side, it's sorted. So this is also creating and providing low quality products which can create confusion and threat safety of consumers. As you have indicated in the background of this conference, the number of virtual transactions has increased significantly throughout the pandemic, and IP owners have and continue to strive to prevent the trading of counterfeit products through e-commerce platforms. A problem that was existing in the past, but that has been growing throughout with the growth of e-commerce trade. This has led to the groundwork of more concrete actions to strengthen IP enforcement, and especially we have to work to grow the economy post-COVID. Tackling counterfeiting and piracy will be crucial in that in order to actually put back the clocks, if I can put it that way. And our office, the European Union Intellectual Property Office, which mandates me as the IP Attaché here in Beijing, not too far away from you, is working to commit financial and human resources to these efforts wherever our mandate allows it. One of the best examples of the synergies has been the hosting of the European Observatory on infringements of IP rights. One of my colleagues will be intervening with later, Antoine Aubert, and these are the mandates from our office. This provides an excellent platform for us to contribute our resources, not only domestic or regionally, but regionally and internationally on the efforts that are so important in today's time. Through its monitoring and evidence gathering, such as the studies that I mentioned earlier, our office is providing high quality studies, but also training support to IPR enforcement at all levels, on the administrative side, on the civil, and also looking at synergies to be further built. The tackling of counterfeiting and piracy is a challenge for all of us, larger companies, corporations, but also in particular to SMEs because of their more limited resources and more funneled resources. So our office strategic plan for 2025 has a core focus on how to make the IP system work better and be improved for all businesses in general, but especially also and in particular to SMEs. We are doing that in line with the industry strategy and the IP strategy published by the European Union. And we have therefore been working on a range of issues, including, as I mentioned, of the important SME support with the member state IP offices and through our office and the European Union Intellectual Property Network, the European Commission, of course, and all Directorate Generals at the Commission. For SMEs, the ID is powered for Business SME Fund, which is an initiative from the office. We are offering continuous support and professional advice and financial assistance to help SMEs in the EU to apply for trademarks and designs, which is obviously a starting point. The growing awareness of the need to tackle counterfeiting and piracy is a tribute of the collective work that we have continuously done. In his opening remark, the chair was indicating how old the IP system is, and it is true. It is, however, an environment with moving goalposts and changing targets. And that is why, because of that, the challenges have been increasing over time. And we have undeniably taken an international dimension more than ever before, especially through global trade, globalization, but now especially with online e-commerce, which take an international priority and position. So it is, and it will continue to be a real priority to have and coordinate strong coordinations between the competent authorities, right holders, the intermediaries. We've mentioned about the platforms, e-commerce platforms. The presentations we'll have today and the discussions we'll have are going to be focusing at all that and introducing the existing situation, the new trends in counterfeiting goods, but also the efforts to prevent counterfeit products and in public and private sectors. So I really look forward for the presentations and the exchanges on that. As I said, the work that has been achieved in the past has been reliant on our joint work, private and public sectors, and it is essential to continue on that and increasingly so. Thank you.
Thank you very much for those points and great insights, Benoit. I totally agree with you that there's something that is necessary and importance of the support for SMEs too. And I believe that IPR Conference is an excellent start of our future cooperation between us. So last but not least, I would like to invite Mr. Samsup, the Director General at the Korean Intellectual Property Office.
Good afternoon. My name is Samsup. I'm Director General for IP Protection and International Cooperation Bureau of Korean Intellectual Property Office, KIPO. First of all, I'm truly pleased to celebrate with you the 2021 IPR Conference, and I'd like to express my gratitude to Chairperson of European Chamber of Commerce in Korea, Dirk, Lukat, President of the ECCK, Eitle, and everyone involved for hosting this event with KIPO. My special appreciation goes to Your Excellency, Maria Castillo-Fernandez, who is Ambassador of the EU to Korea, for joining us today. Last but not least, honorable speakers and distinguished guests from all over the world, I deeply thank you all for taking your time to attend this conference, and please accept my warm welcome. Europe and Korea are far from each other geographically, but close when you think of economy. The fact is that Europe is Korea's third largest trading partner. We are also close in terms of intellectual property. Europe and Korea are both a regular member of IP5, TM5, and ID5. And the number of IP applications filed by the residents from each region to one another's office is continuously increasing. KIPO has started to holding this conference with ECCK from 2013 to discuss IP protection issues with our key trading partner, Europe. Since then, this conference has been providing us, all attendees, with a valuable opportunity to learn about the latest status of IP rights systems in both regions. Distinguished guests, counterfeit deceive innocent consumers who buy them believing they are genuine product. Counterfeit get a free ride on trademark holders' year-long effort. So counterfeit must be eradicated for both consumers and trademark owners. To achieve this, KIPO is working hard to strengthen Korea's IP right protection system. For example, we have introduced a punitive damage system that allows victims of willful trademark infringement to seek compensation for damages up to 3 times of their loss. Additionally, the non-face-to-face transactions have rapidly increased due to the technological advancement and also the impact from the COVID-19 pandemic. Minding this, KIPO has recently expanded and recognized our Special Judicial Police Division to respond more strongly against counterfeit, both online and offline. Such accomplishments have been possible thanks to your keen attention to and support for Korea's IP protection system. I hope today we all have the opportunity to broaden our mutual understanding in anti-counterfeiting in Europe and Korea, and hope to continue our discussion on improving the environment and system in Europe and Korea for IP right protection. In closing, I'd like to express my heartfelt thanks again to all the people who worked hard to prepare this conference, and wish you all at this conference every success in your life and work. Thank you.
Thank you for your remarks, Director General. Since he is newly appointed as the Director General of the Intellectual Property Protection and International Cooperation Bureau in Korean Intellectual Property Office, I think this conference becomes the very first step to our future collaboration. So we will now proceed with the presentations by a host of expert speakers. As mentioned, please use the Zoom chat function to let us know any questions you would like to have addressed to the speaker. We will try to manage them during each session. For our second presentation, we will be joined by Mr. Benoit Lory, Minister Counsellor at the Trade and Economy section of EU Delegation to the Republic of Korea. The presentation title is on illegal content online and the role of intermediaries. Benoit, the floor is yours.
Thank you. Thank you. I'm so pleased to be here this afternoon for this annual IPR conference co-organized by ECCK and KIPO. In the fast changing environment, we need more than ever to make sure that our IP environment infrastructure can adapt to the 21st century. Our business needs a solid and predictable IPR enforcement regime online and offline. In that respect, the EU on 25th of November has published its IP action plan. No, I was muted. I don't know from when, but I was mentioning that the EU on the 25th of November has published a very important IP action plan with the view of upgrading the EU IP system, and in particular to ensure the better IP enforcement through various actions, such as strengthening the role of enforcement authorities, in particular the European OLAF agency, or to establish an EU toolbox against counterfeits, to reinforce stakeholder cooperation through MOUs, etc. However, this afternoon, I would like to focus on the complementary initiatives taken by the European Commission to modernize its digital framework. This is the proposal for the Digital Service Act and the Digital Market Act that has been published on the 15th of December 2020. This is a complementary to the IP action plan, but it's also broader to the IP action plan. And even though this afternoon I will mainly focus, and I will exclusively focus on the Digital Single Act, you have to understand that it's not two separate proposals, but they are a single set of rules, which are the new landmark rules for online platform in the EU. The Digital Single Act clarified the rules and the responsibilities for online platforms, while the Digital Market Act ensures or foresee for a level playing field and a fair competition. This is, why do we need such modernization? This is mainly driven by the fact that digital services have developed greatly. Just remember where you were in 2000, at the moment where the current legal framework in the EU for online services was adopted. In 2000, Amazon only sold books. Downloading a song took several minutes and sometimes even hours. But since the business model as well as the services offered have evolving constantly and much faster than any legislator could follow. We also need to be careful. We often focus our discussion or our intention to the big players or to the big one, the one which are the best known. But it's not only about GAFAs. It exists around 10,000 platforms in the EU. The large platforms, the very large platform, only represent 8%, while the micro platforms represent 42% and the medium 37%. In the meantime, also, the growth of the use of internet has also brought an increase in illegal content spreading online. During the public consultation that has been running in order to prepare the proposal for the new regulation, it was clear that users are regularly confronted with illegal content. And just one figure that I would like to highlight is the size of the counterfeit products over the internet, which represent 121 billion euro loss for companies. The current legal framework then is dated back 2000, and it's the e-commerce directive, which provide for the minimum harmonization of the exemption of liability. And for hosting service, the exemption is even conditioned to their expeditious action. It's something very important. The e-commerce directive and the EU system harmonize the exception. It doesn't harmonize the liability. Otherwise, it would have been meant that we would have to harmonize the tort or the criminal law. The EU system, the current EU system, is neutral. It means that it doesn't define what is illegal. The illegality is defined by national law, not by the EU law. It's an horizontal system. It means that all illegal content, civil or criminal liability, are captured under the current system. And it applies for services or to services. It means that a platform is not seen as an intermediary in the system, but is looked at providing intermediary services. And a provider can provide many different services like merconduit, caching, or hosting. And a very important feature under the current system is that it's general, it prohibits to impose general monitoring obligation. But the system also forces that the member states can impose to internet service provider to promptly inform the competent public authorities of alleged illegal activities or information, or to communicate to the authorities information enabling the identification of recipients of their services with whom they have storage agreements. And they can also impose a platform to monitor specific cases. But the e-commerce directive has also some holes, some missing elements. The first one is related to the action taken by the platforms. Around 90% of the content that is deleted from platforms is done based on their own community standards. But there is no transparency, no accountabilities, and no redress against this decision. The second one is linked to the increasing need for regulatory actions, and this has led to a higher legal fragmentation between the member states. And this is a patchwork of different legal actions depending on the member states, which only big companies can afford. Therefore, what are we proposing in the Digital Service Act? The objective is to modernize the e-commerce rules while keeping the principle behind the e-commerce directive. And that has been very clear from the public consultation that the Parliament, the stakeholders are very keen to keep the system of exemption of liabilities and to complete this with other features. Therefore, the proposed rules are still horizontal by nature. It's not an IP-specific rules. There are still existing specific sector legislation like the copyright legislation, the IPR directive, the enforcement directive for IPR. And the Digital Services has taken from the e-commerce directive the liability exemption for intermediary services plus the prohibition of general monitoring obligation. In the slides, it's the square which is orange, and that has been moved from the e-commerce directive to be included into the Digital Service Act. And to this set of known features, which have been very well identified also by the European Court of Justice. The Digital Service Act has added some very important new feature like the more transparency and precision toward the consumer. A very important element is the due diligence obligation. It means that the Digital Service Act separates the liability from the responsibility of due diligence. And I would like to stop a little bit more on this new and very important obligation that has been introduced by the Digital Service Act, which is the due diligence notion. The Digital Service Act also separate or consider different type of platforms, different type of service, internet service provider. There are 4 categories, and the Digital Service Act propose different due diligence obligation tailored to the type and societal impacts of the service provider, meaning that for smaller intermediaries or hosting services, the due diligence obligation are less than for the online platform or for the very large platforms. And all these due diligence obligations are cumulative obligations. And these asymmetric due diligence obligations are introduced in order to improve the fight against illegal and harmful content online, to empower also users and stakeholders, and to improve transparency. And in this diagram, you can see that the DSA proposes a full battery of due diligence obligation, which can be reasonably expected from this provider, regardless of whether they are covered by the safe harbor or not. And the higher a service is in the tech chain, the more responsibility it has. And with this obligation, the Digital Service Act also intends to improve the cooperation between platforms and authorities, and more globally to improve the cooperation between stakeholders. Just a few words about this very important type of platform, what we call the very large online platform. For them, the Digital Service Act really provide for a very reinforced obligation. In fact, from the past years, we have always heard from the big platform that they have done that. They are responsible, and they are looking for internal and ad hoc solutions. Now we need to take their words, and they need to implement, and we need to be able to assess their obligation, assess their responsibility. And in that respect, the Commission will check very closely the reports and the policy implemented by the very online platforms. And as you know, these platforms are often bigger than some national administration. Then how can a member state alone enforce the rules and the obligation that are to the platforms? The Digital Service Act has reserved for that an important role to the Commission to enforce directly this specific obligation for very large online platforms. And this is a lesson that we have taken from the GDPR system for the protection of data privacy. we don't want, and under this Digital Service Act, we don't want to leave one member state alone to enforce the rule across the EU, like in the GDPR, where Ireland had to enforce the GDPR to cover the whole EU. In case of breach of the Digital Service Act obligation, the various sanctions are and fines are foreseen, which could amount up to 6% of the provider turnover. Now I would like to move a little bit to the benefit of the DSA to the protection of the IP rights. We are in IP conference. I think it's important that at least I dedicate some time to the to this aspect. Among the 9 blocks of the DSA, I will quickly go through several of them, not all the 9, but those which can bring an important added value to the fight against piracy and counterfeits. And the first block I would like to mention is the notice and action procedure. Under the DSA, under the Digital Service Act, there is now an obligation of establishing notice and action, and we are looking for harmonization, the notice and action for all hosting services through, for instance, standardized contents of a notice and submissions of notice by electronic means. The idea behind that is to facilitate the communication between the actor, between the platforms and the users and the companies. In addition to the standardization or to the simplification of the process, the DSA also provides for a complaint handling system. When a platform decides to suspend a user account, up to now, the user had no, under the EU current legal framework, had no possibility to react. With the DSA, the user will have 3 options to lodge a complaint against this decision. The first option will be to be provided by online platform. They will have to provide this complaint system. The second possibility will be through an out-of-court dispute settlement, meaning that under the DSA, each member state will have to appoint a digital service coordinator, which will certify the possibility to have out-of-court dispute system. And the third option will be the usual one through the courts, and with effective remedy and the right to a fair trial. Another important mechanism that is covered by the DSA, it's the notion of the mechanism of the trusted flaggers. Under this new regulation, the trusted flagger are entities to be approved by the EU as having expertise and competence in identifying illegal contents. And because of their competencies and knowledge, they will be the platforms will have to provide a speedy mechanism and to deal with them by priority compared to the normal notice and action mechanism. And this trusted flagger mechanism is limited to the medium, large, and very large online platforms. Another important point of the new regulation, it's a better mechanism to regarding the repeat infringer. It has been for many years the real difficulties and the bottleneck, how to be sure that the accounts of the repeat infringer are definitely taken out. And we have the DSA provide for a specific policy regarding repeat infringer with the objective to contribute to deterring rogue sellers, and notably from the non-EU countries. Another very important element is the increase of transparency. There are several layers of transparency obligation under the DSA. With the objective, it's really to get more information on how the content is removed, ranked, recommended, and advertised. Either with a better publication of the terms of reference, with a better transparency towards the very large online platforms. And just to regarding the online platforms, there is a very important mitigation that they have to take into account. They will have to enforce a risk-led policy, and the idea is to really to develop cooperation with stakeholders through code of conduct or MOUs or other systems of stakeholder cooperation. That's a very important aspect. Another new obligation created under the DSA is what we call the Know Your Business Customer. It's a new obligation on traceability of business users in online markets, and it's to help identify sellers of illegal goods. It's also an important measure to deterring the rogue sellers, in particular from outside the EU. The current system also provides for a patchwork of a court system or recourses, and under the DSA there is a new possibility now. A Dutch court will now be able to ask directly, a Dutch court or another court for many member states will be able to directly ask platforms to remove listing of counterfeit goods or to give information about users, and that these national members or this member state court will be able to do it directly without passing through other means. Just to summarize, the DSA, as I always said, is not an IPR enforcement tool. It's general and horizontal. But when you look at IPR issues, it includes a full toolbox that can be very useful for the enforcement of IPR, in particular the reinforcement of cooperation, the due diligence, and the transparency policy. And of course, this DSA is complementary to the already existing IPR rules that I mentioned. Thank you very much.
Thank you very much for your excellent insights on online counterfeiting and its relevant acts in the EU. It is such an informative presentation that you explained the modernization of EU framework that compared to year 2000, the EU has built up its Digital Services Act in 2020, and it operates as a full toolbox, which can be very useful for the enforcement of IPR. So we will now move on to the third presentation, which is the IP infringement on social media. This presentation will be delivered by Mr. Antoine Aubert, IP Digital Specialist of European Observatory on Infringements of IP Rights at European Union Intellectual Property Office. So Antoine, the floor is yours.
Good afternoon. Can you confirm you can see my slides? Yes, no?
We can hear you and we can see your screens very well.
Okay, many thanks. Many thanks, and thanks for the opportunity to present the work of the EUIPO Observatory on IPR infringement. Today I will talk about IP infringement on social media. I think for many years we've seen throughout our studies the misuse of social media for IP infringing activity, but so far we hadn't done any specific studies or report or analysis that were focusing on social media. And so today I will present you very briefly two reports that we've published today. One that is a quantitative or first attempt of a quantitative analysis on the misuse of social media for IP infringing activities. And the second one is a discussion paper that we've published on the challenges raised by the misuse of social media for IP infringing activities, but also the good practice to address some of these challenges. Just moving on, the first report we published back in April from this year. And this is our first attempt to look at the extent to which social media are used for IP infringement activity or promotion of such activity. What is the relative presence of IPR infringement product and illicit digital content on social media compared to a genuine product or licit digital content? And what kind of IPR infringing business model are used on social media? And so we've been using social intelligence analytics through four main social media services, gathering public posts, about 4 million of public posts in 7 languages, to try and again identify the extent to which social media are used. There's lots of data in the study, and after this presentation I'll post a link to the study, but just to give you an idea of the scale of what we're talking about, if we're looking at counterfeited good and percentage of public conversation related to counterfeit, the monitoring exercise estimates that 11% of the public conversation are related to counterfeit. If we look at percentage of conversation related to pirated content, the study estimates that around 35% of the conversation are about finding piracy content. And so this is our first attempt to look into this phenomenon. It gives an order of magnitude of what we're talking about, and we'll keep refining the methodology, and we'll keep thinking on how we can better assess and better estimate the use of social media. But I think this figure shows that there are significant use of social media for IP infringing study. In parallel to the work we've been doing on a quantitative analysis, we've also been working on a discussion paper on social media together with an expert group we have on cooperation with intermediary. And we've been looking at existing trends in the use of social media for IP infringing activity, and most importantly, good practices to address them. So a group of experts from intermediaries, from IP owner, really looked into how social media are misused, the challenges raised, and the good practice to address such a challenge. The group first looked at how to define social media, and that sounds like something easy, but it's not that easy. We tend to see social media as one service, but social media are a mix of all different kind of functionality. And so the expert group came up with a definition of social media and different criteria to define social media. I did not put it there, but one thing to keep in mind when we're talking about social media is we're talking about services that have all different kind of functionality. They can be used for personal use, they can be used for business use, they offer ad services, and there are a mix of different communication channel. So social media, you can communicate publicly through public posts that are open to the world, that are out there for everybody to see. Increasingly, these public posts are what we call ephemeral content. So this is content with a limited lifespan, and that will disappear after a while. So a post can disappear after 24 hours. So that's for the public part of the social media. Social media are also allowing their user to communicate with selected group, and so that can be your social connection, but increasingly that can be closed group. So invitation-only groups where users are invited to sign in and then have to be admitted in a group to actually participate in the conversation. And we are the it's the fine line between public communication and private communication. And of course, social media are offering instant messaging, so private communication functionality. And so the mix of all this functionality is allowing IP infringer to use this different functionality for their IP infringing activities. And we've been identifying a number of IP infringing use of social media. Some of the use are not are not particular to social media. They're the same for any other services offering the same function. And so we've been looking into social media that are used to host IP infringing content. Increasingly, social media are offering live streaming functionality. And so this live streaming functionality can be used to infringe IP. And they can also be used to link to third-party websites where IP infringing activities are taking place. There's also the use of social media to support IP infringing activity, and that's where we see advertising function of social media being misused for IP infringing activity, but also non-paid marketing and social media really being used to market IP infringing activity. There's obviously the use of and a growing trend that is influencer that are actually promoting lookalike or fake products. This is what is called the dupe culture, and so influencers that are posting, they're doing some videos about counterfeit good that really looks like the real thing, and so that's one trend that was identified. Lots of accounts that are created, sometimes automatically, and that we call burner accounts, that are posting in the main channel of brands or brands fan, trying to attract an audience and building an audience for their account, and in many instances approaching some of the social media users to offer IP infringing goods. There's also scam accounts, accounts that use the trademark or a specific trademark and that are confusing the user on whether this is an official account, whether this is an affiliated account, and so misleading the user and believing that they are actually related to the legitimate brand, but are effectively there to sell, market IP infringing products. There are the use of social media to provide information about IP infringing activities and some of the trends that have been identified. Support forum for IP infringing services or general information about IP infringing activities. A lot of IP infringing websites have a social media account where they can interact directly with the user to make sure that they can effectively use their services. One thing that we've seen is an internet website infringing IP being taken down, and the social media account being used to post a new website where user can go and continue to use the IP infringing services. Last trends that were identified by the expert group is the use of closed group and private communication service. And that's where we're touching upon the specificity of social media that makes misuse of social media particularly challenging. As I explained, social media can allow a mix of public-private communication. And what we see is IP infringer attracting user towards closed groups or invitation only groups where they further advertise their IP infringing product, and in many instances can finalize the transaction through private messaging services. So a combination of public and private communication that makes social media particularly interesting for IP infringer. And so that's why he's on the next slide when it comes to the challenge. This combination between public-private communication is actually being used to escape existing IP protection measure and investigation techniques. And so mixing this different functionality, we see IP infringers that are really able to hide their activities, especially in the context of a closed group or using a private communication, and making it particularly challenging for IP owner and law enforcement authority to actually track down and be able to identify IP infringing activities. Now, this is made even more complex by the fact that there are different regulation applying to different type of functionality. And I think the previous speaker talked extensively about the e-commerce directive and the way public content that is posted on all different kind of online platform is currently regulated. And so when it comes to content publicly available, there's one type of regulation in Europe, the e-commerce directive that was mentioned, where there's a possibility to ask for the takedown of the content. But private communication, so closed group and instant messaging application, are regulated in different way. And access to personal data for alleged IP infringer is regulated under the IP Enforcement Directive and is regulated in a different way. And so these different regulation impact on the capacity for social media to cooperate with IP owner and law enforcement authority, because information you can provide about private communication is very different than information you can provide about content that is publicly available. So that's for the challenges, well, for the trends and the challenges. Now, the good news is that there are a number of good practices that are developing to address these trends and challenges. And the expert group has identified more than 20 good practices. And we've been classifying them in preventive good practices and reactive good practices. So everything that can be done before an IP infringement is happening, and everything that can be done after an IP infringement is happening. And so a number of good practices identified are covered by the proposed Digital Services Act, and the previous speaker has been presenting extensively what is coming with the Digital Services Act. And so some of these good practice that we have identified, like repeat infringer policy, know your business customer requirements, or notice and action mechanism, and information to the user in the context of this notice and action mechanism will be covered by the Digital Services Act. But there are also a number of good practices that goes further, especially with regard to protection of IP, and that's where I would focus my presentation. Looking into preventive measure, we've been identifying, again, a few good practices. I will just talk about a few, but there are measures to detect new account created by previously disabled users. So how do you prevent somebody that has already been taken off of your services to come back? And so we see certain social media, in particular social media that are based on app, that are implementing a number of measures to prevent an account that was created with a specific mobile phone number or device ID, well, a user using a specific account device or phone number to reopen an account. And so this is particularly effective to prevent burner accounts that are just created to infringe IP. There are also some good practices with specific requirement to access a certain functionality. And so typically, not being able to immediately use the online, the e-commerce listing functionality or the live streaming functionality. And so only allowing users that have been using the service for a certain time to be able to use that kind of functionality. So this is another good practices that can prevent the development of burner account. Another very interesting good practice that was identified is a specific requirement to use certain keywords in profile names. As I said, we see IP infringer creating a profile to kind of give the impression to the user that they are kind of affiliated to the brand owner or that they are the official account of the brand owner. And so we've seen some, well, one social media that is actually doing a list of well-known trademark. And if a user wants to use one of these trademark in its profile names, it's actually going to ask the user to show ascertain its right to use the brand. And this is a pretty effective, good practice to prevent scam accounts and fake profile that are impersonating trademark. In terms of reactive good practices, again, I will just give you a few. There are many that were identified, but one that was considered as particularly effective is the verification of associated content and an account. So if if some IP infringing content is detected onto a specific account, it is notified. The social media is actually going to look into the entire account and potentially associated account to see if this specific user is also, well, has been infringing the rights of other IP rights. From the expert, we got that in many instances, IP infringer were infringing multiple rights. And so this was seen as a good practice to prevent an IP infringer using social media to infringe multiple rights by just having one notification about IP infringing content and looking into the content of the entire account. Another good practice is notification of user name infringement. And so the possibility to, for trademark, to notify accounts that are misusing their trademark to either, well, infringe their rights or mislead the user. And so not only notifying potentially problematic content, but problematic username. Again, there can be perfectly legitimate use of trademark in username. So the IP owner will need to demonstrate that the use is there to mislead the user or for IP infringing activity. But this is a good way to prevent scam and fake profile. Two last best practices. We've seen some social media or one social media allowing IP owner to register their rights with them and to reserve or limit the use of the trademark related keyword in the account profile. So similar to what I said before, it's actually the same social media that is not only looking into well-known trademark and restricting the use of well-known trademark in user profile, but is also allowing IP owner to register their right with them, ascertain their rights, and then we'll reach out to them and then we'll ask the user using the the trademark in the user profile to ascertain its right before it can actually do so. And again, this is a good practice that can be useful to fight against scam and fake profile. The last good practices that I will talk about is infringing website lists. So there are a number of infringing website lists that are out there, including the EUIPO list that is mainly there, that is gathering IP infringing lists from different countries, mainly for the purpose of preventing, well, allowing advertisers to make sure that their ads are not showing up on that kind of website. And there are some attempts for social media to actually use that kind of list. And this is seen as a good practice that can help deal with the problem of closed groups, so where IP infringement is and conversation about IP infringement are happening inside closed group, that so not public content, and so where it's very difficult to see whether IP infringing activities are occurring or not. But at least you can prevent this closed group to point towards IP infringing website. And so there are some attempts to actually discuss with social media to make sure that they use that kind of list and do not point, and their closed group do not point towards IP infringing website. Just to conclude, the key finding of the work we've been doing, obviously there's multiple ways IP infringers are combining social media specificity and functionality to support their activities. And this is a real challenge because they are doing so in many instances to defeat existing IP protection and investigation measures. But on the positive side, there's a set of good practices that can contribute to limit IP infringing use of social media functionality. And we hope that with the discussion paper we publish, this would be a way to advertise that kind of good practices and promote that kind of good practices and hopefully see different social media looking into what is done by others and potentially implementing some of the good practices that are out there. With that, I thank you very much for the opportunity to present the work of the Observatory. I will be posting the links to the two reports if you're interested in finding out more in the chat. And we're always interested to get questions, to get reaction on the report. So do not hesitate to reach out if you do have any question about this report. Many thanks.
Yeah, thank you very much, Antoine, for highlighting the findings of these studies, providing us the brief overview of them, which mainly deals with IP infringement in relation to the uses of social media. It really helped me to understand that since social media have different functionalities in various communication channels, they're widely used for IP infringement these days. And also it was great that you shared the good practices and you mentioned the importance of collaboration between IP owners and law enforcement authorities to prevent such infringements.